This is the Ministry of Truth. I'm Gordon Comstock, and this is part 9 of Woe Unto You, Lawyers by Fred Rodell from 1939. Yes, it most certainly is out of print. This is part 9. It's chapter 10, A Touch of Social Significance. Quote, "Laws grind the poor, and rich men rule the law," unquote. Oliver Goldsmith. In case it should not yet be perfectly apparent, it may be worth stating here and now that the purpose of this little inquiry into the law and its mysterious ways has not been, and is not, what today would be called, quote, socially significant, unquote, purposes. That is, it has not been to prove that the law, in terms of its results, oppresses the poor and favors the rich, and is a tool of the big corporations, and is almost always on the side of wealth, Wall Street, and the Republican Party. Practically every critical book on the law ever written attempts to prove just that, and there are hundreds of them. The trouble with them all is not by any means that they are not, for the most part, quite right. The trouble is that they get just that far and no farther. Sounds like a criticism against those who halfway get it and get stalled out listening to NPR or Dr. Stan Monteith or something interesting. Their authors, who are usually lawyers, have no basic quarrel with law as a method, a science, a technique of running the world. They merely want to see it work for their side. They are not out to tear down the law. They are out to remodel it slightly so that its results suit them better. The purpose of this little inquiry has rather been to show that the whole pseudo-science of the law, regardless of its results, is a fraud. It is just as much of a fraud when it sends Dick Whitney to jail as it is when it sends to jail a starving man who steals a loaf of bread. It is just as much of a fraud when it favors sharecroppers as when it favors coupon clippers. It is just as much a fraud when it protects civil liberties as when it protects the profits of holding companies. It is just as much of a fraud when handed down by a quote-unquote liberal court as when handed down by a quote-unquote conservative court. It is a fraud, not because of its results, but because of the manner in which it purports to arrive at them. Yet no inquiry into the law could pretend to be complete without at least some slight consideration of the law's famous tautological boast about, quote, equal justice for all, unquote, for the boast is a lie. The law not only can be bought, although usually not in so direct a fashion as it was bought from ex-Judge Manton, but most of the time the law has to be bought. And since it has to be bought, its results tend to favor those who can afford to buy it. Moreover, the fact that the law is constantly for sale and generally to the highest bidder ties right into the fact that the law as a whole is a fraud. For the law could not be bought, and it would not favor those who can afford to buy it, if the vaunted principles of which it is fashioned really were the ready keys to certainty and justice which the lawyers claim them to be. It is because those principles are so many and so meaningless, because they can be chosen and twisted and sorted out to support any result under the sun, that the law does not produce justice, parenthesis, which in itself implies equality of treatment for all, end parenthesis. In considering how and why the law has to be bought, it might be well to remember once more that the law is not the laws, as most people think of the laws. It is true that legislatures and members of legislatures and members of Congress have been bought, or at least paid for, so that they would vote for or against proposed statutes which would affect the interests of those who did the paying. But this practice, though deplorable, is a minor phenomenon compared to the day-in and day-out purchase of the law. For the law is that body of abstract, amorphous rules which supersede written statutes and even constitutions, and under which the lawyers and the lawyer judges resolve all our problems, settle all our disputes, and run all our lives. It is well worth buying. How, then, is the law bought? How is it regularly turned to the account of those men and those companies who have money enough to pay what it costs? The law is bought, to put the answer bluntly and briefly right at the start, by hiring the services and the advice of the smartest lawyers, of the professional soothsayers who are most adept at manipulating the principles of which the law is made. It is bought by paying a premium, in court and out of court, to the 20th century medicine men who can best cast spells of legal language to protect and defend the personal and financial interests of those who would be hard put to protect and defend such interests in terms of justice, undiluted by law. Truly, now this is me talking now, Gordon. Truly, we live in an age, we live in an era in which bean counters thrive. I recall there's a paragraph in 1984 by George Orwell where he looks at the only types of people who can survive in his totalitarian world, who can appear to be thriving, and he calls them little beetle-like, scurrying around people with, they have no aptitude for critical thought. They do what they're told, and their physicality is not imposing. They're sickly, but what they are efficient at, the only thing they're efficient enough at, is counting. Taking orders and counting. This is the era in which we live. Virtue is out the door. Virtue is not important. Seeing the big picture, having talents like that, having virtues and true talent, none of that matters. This is an epoch in which bean counters thrive. Open up your local classified help wanted ads, and you will see what kind of jobs outnumber all of the other jobs. You will see full-time and part-time, bookkeepers needed, bookkeeper needed, bookkeeper needed, bookkeeper needed, accountant needed, CPA, payroll clerk needed. Over and over and over. This is an era of the beetle-like bean counters scurrying around. And all of you out there who have any real talents, who have more of your humanity in you than the bean counters, more of the image of God in you left over, that the bean counters, the beetle-like scurrying around talentless people, those people are really, I want to say in the image of Satan, or they're certainly doing the bidding of Satan, putting numbers on people, worrying about the little nitpicky, useless things like Fred Rodell is talking about. Of course, those people do very well working for the IRS. And they do very well as contract lawyers and bookkeepers and accountants and CPAs, etc., etc. Continuing with Fred Rodell, woe unto you lawyers now. Now most people, if they think at all about what money can do in the way of legal protection, think exclusively about criminal law. They think about Leopold and Loeb being able to hire Clarence Darrow to keep them from the electric chair. They think about the Mitchells and the Insulls, the captains of industry, who get caught doing strange things with other people's money and who can then buy the services of the cleverest and yet most respectable members of the bar to save them from legal punishment. People contrast such goings-on with what happens daily to the ordinary murderers and ordinary thieves who can only afford the cut-rate prices charged by poorer lawyers, who have to have their lawyers supplied them free and third-rate, just so that the outward appearance of the justice for all ceremony may be maintained. And most people realize that there is something distinctly unfair about all this. There is, but it is only a very small part of the story. In the first place, criminal cases, though they take up most of the newspaper space devoted to the law, take up only a fraction of the time of the courts. The bulk of the business of the courts is given over to what the lawyers call, quote-unquote, civil suits, in which one person sues another person, or one company sues another company, usually over some financial or business squabble. In these cases, just as in criminal cases, and it is particularly noticeable when a corporation is on one side of the dispute and a lone individual on the other side. In these cases, the most money buys the best legal assistance. And the better your legal assistance, the better your chance of ending up with the law in your favor. For, as cannot be repeated too often, the law is not by several long shots the certain and exact science as which it masquerades. If it were, even the richest corporation in existence would not throw its money away on the tremendous fees that the leading lawyers charge their clients. Any lawyer, or perhaps no lawyer at all, would do just about as well. But the corporations know, and the lawyers know, that a master manipulator of legal mumbo-jumbo is a far more useful thing to have on your side in a lawsuit than all the certain and impartial justice in the world. True, in a great many legal disputes there will seem to be more principles of law, or more compelling, in the abstract, principles of law available to one side than to the other. But the other side will always have some principles left to play with, And just as in the game of bridge, so in the game of law, an expert player will beat a run-of-the-mill player 9 times out of 10, despite the fact that he may hold worse cards. Yet, it is not only, and not chiefly, in the purchase of smart counsel to represent you in actual court cases that the law has to be bought. The law, although it oversees all human affairs, does not apply itself automatically to the settlement of human grievances. The man who thinks he is being cheated in a personal or business way, who thinks he is being deprived of his just rights so clearly that it is even a violation of the legal system of far-fetched principles, must go to court to try to get any satisfaction at all from the law. And it costs money to go to court. It costs money even before the bills for lawyers' fees begin to come in. That is why most people never in all their lives become plaintiffs in a lawsuit. Farmers and factory workers and housewives and unemployed people have their legal grievances just as rich men and big corporations have their grievances. But they cannot afford to buy so much as a shot at the law. A man who is pretty sure the agreement he made is being broken, when the finance company takes away his car or his radio because a couple of payments have been delayed, would not think of hiring a lawyer and going to court about it. It costs too much. A clerk in a big department store who thinks that some new government statute hits him in an unfair and perhaps illegal way would not dream of going to court about it. But the store would go in a minute if it felt cheated by some written law. A workman's wife who is desperately unhappy with her husband and has perfectly adequate grounds for divorce will not sue for one. Well, this was in 1939. She certainly would today, because now we have no-fault divorce. Hey, you don't want out? Sure, come on out. Pay the lawyers, but you're okay. And often, of course, the one who's faithful in the marriage gets screwed. Anyway, divorces, like suits against the government and legal efforts to get a fair deal in ordinary business arrangements, and like almost every kind of law in the book, are the exclusive luxuries of those, and there are very few of them, who have money enough to pay for the law. A several million-dollar corporation recently complained in print about the terrific cost of carrying to and through the courts a protest against a ruling of the National Labor Relations Board. The point was well taken. Yet it serves quite nicely to emphasize the helplessness of the ordinary man with a grievance that he would like to expose to the law. The corporation at least could and did afford to pay the thousands of dollars necessary to get a legal hearing on the wrong that it thought had been done it. But what chance, for instance, would an employee or a customer of the corporation have to air his complaint in court if he thought he had been unfairly and illegally treated by the U.S. government, or, for that matter, by the corporation itself? The disadvantages of the corporation up against the U.S. government in a matter involving the law are as nothing compared to the advantages the corporation holds over every individual who works for it, buys from it, or invests in it, wherever the law is or might be concerned. Still, it is not in buying smart soothsayers to talk for you in court, nor even in buying your way into court in the first place, that the law is most commonly and most effectively sold and purchased. Most of the business that lawyers handle and live on is made up of matters that never get near a courtroom. Most of the business that lawyers handle and live on is made up of what is called legal advice, usually about financial matters, that is tendered at a price to those men and those companies that feel it will be well worthwhile to get the law safely on their side before they embark on any money-making or money-saving deals of any kind. And legal advice amounts, for the most part, to casting spells of legal language over the wording of business documents, so that the documents, if they ever should be dragged into court, will show that, regardless of where non-legal justice may seem to lie, the law is pretty clearly on the side that bought the legal advice. To take a very simple example, suppose a man should set up a parking lot and hand out plain numbered tickets, like the checks you get when you check your hat in a restaurant, to everyone who parks his car in the lot. Suppose a woman should park her car and leave her fur coat in the back seat and should come back to find the fur coat gone. Suppose, moreover, that she would be mad enough and wealthy enough to sue the parking lot owner for the loss of her coat. The chances are strong that the law, after tossing abstract principles around in confusion, might hold him responsible for the loss and make him pay her the value of the coat. Yet most people who lose articles out of cars left in parking lots have scarcely a Chinaman's chance of getting a cent out of the lot owners. Most parking lots are owned by people or companies with money enough to buy legal advice beforehand. And so, most parking checks are not plain pieces of cardboard with numbers on them. They have numbers on them all right, but on the back of the check or at the bottom is printed in small type, quote, "The owner of the car covenants that the bailee will not be held liable or responsible for the loss, theft, and or damages of articles, etc., unquote, or words to that effect. Courtesy of the legal advice, the law has been carefully placed on one side of the potential lawsuit, without so much as the knowledge of one of the, quote, parties to the contract, unquote, that it has been placed there, just in case. It is the same, on a much larger and more complicated scale, with leases. It is the same with mortgages. It is the same with insurance policies. It is the same with stock issues and bond issues, and all the other legal devices by which business concerns of all kinds and shapes earn, beg, borrow, or steal other people's money to use for themselves. There is always that big block of small type, sometimes running to several pages, which the ordinary purchaser or tenant or borrower or lender or investor does not bother to read, and probably could not understand if he did read it. That block of small type is put there at the advice of lawyers, and what it means is that if any trouble should arise over the little business arrangement, the ordinary purchaser or tenant or borrower or lender or investor is almost surely going to lose if he should be fool enough to carry his complaint to the law. For the other fellow, the company or the individual with money enough to afford it, has been canny enough to buy the law in advance. Of course, it often happens in the world of finance and industry that both sides of a business deal are able to hire legal advice right from the start. That is the lawyer's heyday. Counsel for each side, without so much as a minor lawsuit anywhere in prospect at the time, will fight to outdo each other in the clever manipulation of legal language and the careful building of legal fences so that their clients' interests may later be defended, if necessary, in strict accordance with the principles of law. Yet, unless one set of lawyers is much smarter than the other set of lawyers, both sides might just as well dispense with their lawyers altogether, so far as driving a reasonable and profitable and fair business bargain is concerned. The hitch is that as soon as one side resorts to legal advice, the other side has to use it too in self-defense. Thus, everybody loses except the lawyers, who go merrily on selling the law. But since most business transactions involve a big fellow and a little fellow, a company, for instance, that can afford legal advice, and a customer who can't, the law is usually weighted to one side from the very beginning. It is weighted by lining up beforehand, in the written terms of the transaction, the legal language that will fit right into legal principles in any lawsuit that might later arise out of the transaction. And it is in this fashion, even more than by the hiring of smart word jugglers to represent you in court, or by the purchase of a court hearing to begin with, that the law is regularly bought, and therefore regularly tends to favor those with money enough to buy it. That is why the center of the nation's law business is in New York City, and why the bulk of the nation's influential and profitable law practice is carried on in the Wall Street law factories. People and companies in other parts of the country have their legal grievances and disputes and their court squabbles, and they have them in much greater proportion than the proportion of the nation's law business that is carried on outside New York. But the richest people and the biggest companies make almost all their financial arrangements and their important business deals in New York. And financial arrangements and important business deals, even more than actual legal disputes, are what the lawyers thrive on. Most New York lawyers spend most of their time working out legal advice for the business titans that make their financial headquarters in the city. It may be advice about how to word a series of mortgages, or conditional sale contracts, or leases, or stock certificates, so that the little fellows on the other side of the deals will have little or no chance for legal redress if they should later feel themselves cheated. It may be advice about an intercorporate transaction where the sole real usefulness of the advice will be to counter any tricks of the legal language that the other side, also advised by high-paid lawyers, might try to pull. It may be advice about how to get around a bothersome government regulation and still keep on good terms with the law, which of course is more almighty than any government regulation. Advice that thousands of smaller companies or less wealthy people would love to have too, if only they could afford it. It may be advice about how to make use of legal language so as to get out of paying taxes, as when J.P. Morgan, for all his yacht and his grouse shooting, perfectly legally avoided the federal income tax for a couple of years while hundreds of thousands of $1,500-a-year men had to chip in to the U.S. Treasury. In any case, it will be advice which has a dollars and cents value to the person or the company that buys it, somewhat greater than the stiff price the lawyers charge for it. And the direct or indirect losers in the whole affair will be the companies and people by the millions who cannot afford thus to buy the law. There is no more striking parody of the law's boast that it represents equal justice for all than in the work of those top men of the legal trade who cluster and prosper in New York City. Moreover, most good lawyers go to New York before they die. They go to New York because that is where they can make the most money out of their knack of tossing around legal principles and legal language. As a matter of fact, herds of them are coaxed straight to New York from the law schools every year. And thus, incidentally, the profession gets in another telling blow for the perpetuation of the legal legend. For whatever slight doubts about the reasonableness, practicability, and majesty of the legal process may have been left in the smart youngsters' heads, after 3 years of rigid drilling in the sacredness of abstract concepts, quickly evaporate in an atmosphere where the law is acknowledged king, and the king and his pet courtiers are so handsomely rewarded. Here, too, is the kernel of another reason why the law is kinder to the rich than to the poor. Not only are the most promising young hocus-pocus artists immediately lured to the service of those who pay them the highest wages for their magic, but out of this group spring, eventually, and almost automatically, most of the acknowledged leaders of the profession. For, as in other trades and professions, earning capacity is universally and blindly accepted as the hallmark of real ability. Parenthesis. Benjamin Franklin once paid tribute to this fact when he suggested that the lawyers appoint the judges on the ground that they would always pick the ablest of their clan, so that they might most profitably divide each new judge's practice among themselves. End parenthesis. And, despite the fact that Franklin's scheme has never been put to the direct test, It is out of the acknowledged leaders of the profession, who are acknowledged to be leaders because they make so much money, that most judges are chosen. Now, when a lawyer becomes a judge, he no longer has a direct financial incentive to manipulate the law in favor of the rich people and the big corporations. But he will usually have spent most of his professional life before he became a judge doing just that. What is more, he will not have admitted, even to himself, that he was doing anything other than apply an exact and impartial science to the orderly management of men's affairs. In inevitable protection of his own self-esteem, he will perforce have swallowed most of the legal legend whole, and consequently he will have hardened into a habit of mind whereby justice and the legal principles he is used to using are just about synonymous. When he becomes a judge, he cannot easily shake off this set slant toward the law. The principles and concepts he once flung about and fought for, mouthed now by other lawyers trying cases before him, will still have a familiar and authoritative ring. Such phrases as, quote, freedom of contract, unquote, and, quote, caveat emptor, unquote, and, quote, the sanctity of written agreements, unquote, written by lawyers, and, quote, deprivation of property without due process, unquote, along with all the minor and equally vague abstractions which lawyers customarily defend in and out of court. The interests of their wealthy clients will strike the eyes and ears of the judge as good sound legal doctrine. By contrast, the phrases and principles of law customarily used to argue against such interests will seem less familiar, less orthodox, less compelling. Conditioned by his own past habits of legal speech and thought, the judge will unconsciously lean, in laying down the law, toward the side that talks his old branch of legal dialect, which means that he will lean toward the side where the money lies, and the law will lean with him. There is one more important reason why the law regularly tends to favor the rich, the conservatives, the people and companies with plenty of money and property who, not unnaturally, want to keep all their money and property and keep on getting more of it in the same old ways. The reason is inherent in the very nature of the law itself. For the law, you may remember, purports to be a great body of changeless abstract truths. Times change, and ways of living change, and the facts of human affairs change, but the principles of the law remain unmoved and steadfast. In short, the law, by its own definition, is a stand-pat science. And of course, it is the wealthy and well-to-do who are always stand-patters. The poor and the not-so-well-to-do are the progressives and the radicals. The moneyed groups are, for the most part, very nicely satisfied with the old arrangements of things. Justice or no justice, in the original Christian sense of the word, they don't want to see the rules shifted in the game of getting ahead in the world. And they find in the law a philosophical and less obviously selfish defense of their resistance to change. They also find in the law something more solid and more useful than a philosophical defense of conservatism. For the law, mysteriously brought to earth by lawyers and judges, does control all earthly affairs, and in being transmuted from abstract principles into specific decisions about human disputes and problems, it retains its reactionary flavor. New rules of the game, new arrangements in men's activities, new considerations of what is practical and what is fair, fit less smoothly into the law's scheme of principles than do the old considerations, the old arrangements, the old rules. That is one reason why so much quote-unquote progressive legislation, meaning laws that try to change the rules to favor the poor at the expense of the rich, is either damned entirely or quote-unquote interpreted into ineffectiveness by the courts. The novel arrangements just don't slide easily into the old unchanging principles of law. For instance, the newfangled notion that a worker ought to be paid a living wage didn't stand a chance when it first came up against the age-old law-encrusted right of a corporation to pay its workers as little as it pleased. There might have been a law about it, but the law had never heard of such a thing. Similarly, the idea that a homeless man might be legally justified in breaking into an empty house to sleep, an idea that could certainly be argued from the standpoint of pure, unadulterated justice, would be laughed out of court today, as would the idea that a bond salesman, whose glib assurances had led an old lady to invest her savings, could be sued by the old lady for what she lost when the bonds later became worthless. For the judges will not, if they can help it, go to the trouble of reshuffling the law's huge deck of abstract principles in order to reach and rationalize a radically different set of practical results. Only rarely and reluctantly will they turn the stream of legal logic in a really new direction. Only rarely and reluctantly will they tolerate, in the law's name, far-reaching or basic changes in the manner of adjustment of human problems. Thus, not only the law, but the general trend of legal decision remains the same. And by remaining the same, it favors the interests of those who stand to benefit by a retention of the old rules. It favors the conservatives. It favors the rich. Yes, the, quote, socially significant, unquote, books about the inequalities and injustices of the law in action are right, as far as they go. And, incidentally, a prominent member of the bar recently summed up a large part of their theme in a phrase when he described the ideal client, the lawyer's dream, as, quote, a rich man who is scared to death, unquote. But still, it is the fact that the law, as a whole, is a fraud that lies behind all the inequalities and all the injustices. It makes it worthwhile for those with money enough to afford it to buy the court services and the pre-court advice of those mumbo-jumbo chanters and scribblers who can best wring desired results out of legal language and legal principles. It makes it worthwhile for those with money enough to afford it to buy their way into court if the results they want wrung out of the law cannot otherwise be attained. It is responsible for the myopic inability of most judges to see beyond the one-sided principles they used to use when their own services were for sale to the highest bidders. It is responsible for the inherent inertia, the congenital conservatism of the law in action. For if the law were really the exact and impartial science it purports to be, instead of being an uncertain and imprecise abracadabra devoted to the solemn manipulation of a lot of silly abstractions, none of these bases of inequality and injustice would or could exist. The law is indeed a menace when it works so as to pervert its own boast of, quote, equal justice for all, unquote, when it favors the rich and oppresses the poor, when its results, in the mass or in the particular, seem to be plain denials of ordinary, non-legal impartiality and fairness. The point is that even when the law works, as it sometimes does, so as to produce fair and impartial and practical results, it is nothing but an unnecessary and expensive nuisance. Those results might have been achieved much more simply and easily and painlessly without recourse to the metaphysical nonsense of the law. And it is this point which the, quote, social significant, unquote, boys invariably miss. The quote-unquote socially significant plot has grown stale in the telling. It always revolves around the conventional triangle of the rich, the poor, and the law. And the villain always walks off with Lady Law in the end, which is supposed to show that she is a villain too, whereas actually she is only an empty-headed fool who neither knows nor could be taught any better. Oh, those are fighting words. Those are great. That's great writing right there. Oh, I was going to say fighting words. No, what that is really good prose there. Lady Law. No, she's not really a whore. She's just an airhead who you can't teach right or wrong. Anyway. Wow. Anyway, folks, I'm Gordon Comstock. This is the Minister of Truth, and this has been Part 9 of Woe Unto You, Lawyers by Fred Rodell from 1939. You thought I was going to say out of print, huh? And there I just did. Over and out.